Good morning, Counsel.
Morning. May it please the Court. I'm Peter Krupp. I represent Daniel Rogers. I'd like to address the first two issues in my brief, two erroneous jury instructions, and unless there are questions, I'd rest on my brief on the other issues. Daniel Rogers was convicted of first-degree felony murder, and the predicate felony was armed robbery. The evidence at trial supported the jury finding that Daniel Rogers shoplifted toothpaste from CVS on February 16, 2004. But after being chased outside, he abandoned his effort to effectuate the taking. He dropped the merchandise.
Isn't it too late to abandon once you've grabbed the stuff and you're out leaving the store and you're fleeing? Hard to say he abandoned it when they caught up to him and he started, well, let's assume he started throwing stuff out of his pockets as opposed to they started dropping out of his pockets.
It's not too late to abandon if the charge is armed robbery. It is too late to abandon if the charge is shoplifting. There's no doubt that he shoplifted and could have been charged with shoplifting. But what happened was that he was chased out of the store. He, our theory, abandoned the toothpaste by the curb. There are photos in the appendix that show
while they're chasing him.
Yes. Mm-hmm. He is being pursued. He drops the merchandise at the curb. And then, and there's evidence that then is an appropriate word to use, that it occurs in this chronology. He is grabbed by the collar by one of the people. He is whirled around. He's slammed up against the wall. He is grabbed and prodded, if you will. One witness who's up at a light, waiting for the light to turn, says that she sees an altercation happening on the sidewalk. She sees a black man down on the ground, and people are 3 or 4 people who she describes as Caucasians. She doesn't distinguish between Caucasians and Asians. In her testimony, are punching and kicking the person. The light turns. She turns the corner.
Let me just interrupt you and ask you a question. Theoretically, is it your view that at the point after he had dropped the toothpaste, could he have been charged with anything?
Shoplifting.
But was there any evidence he intentionally dropped it, or isn't the evidence that it was falling out of his pockets as he ran because he had so much stuff in it?
Well, I don't think there was ever any evidence that it was in his pockets. I think that the evidence was it was sort of in his coat. You know, it was a big, bulky red coat.
Okay, so
the coat
is there evidence that he was throwing it away?
There was no evidence that anyone tried to grab it from him. The evidence was that he was either dropping it or it was dropping from his coat. There was no evidence that he made any effort to retrieve it. There was no evidence that anybody took any from him. There was no evidence that any of the toothpaste was moved after it hit the sidewalk.
Is your point not so much that this wasn't, that the instruction was error because this was an abandoned robbery, armed robbery, or that the instruction took away the ability of the jury to decide whether it was or wasn't an abandoned armed robbery?
I would characterize it a little differently, but my quick answer to you is both. My position is this was an abandoned shoplifting.
Okay.
And it was not converted to an armed robbery because of the abandonment of the toothpaste before there was ever any physical force used in response to the force being used against my client, or before any knife came out in response to the physical force being used against my client.
Let me ask you this. So hypothetically, there's a bank robbery, and the robber is given money, and they put it in a bag, and they run out of the bank. They're chased. If they drop the bag, have they abandoned the crime?
Bank robbery, I think, is a felony already. I don't believe they have abandoned the crime of bank robbery. The bank robbery is completed already.
Just say it's charged as armed robbery.
Yes. The issue here is he's completed the shoplifting, to be sure. The question is whether that shoplifting, once abandoned out on the sidewalk, or that merchandise once abandoned there, converts to an armed robbery simply because in the context of trying to escape from being apprehended from a crime he's now abandoned, he's running away from, he's given up the merchandise. The question is whether at that point, just trying to escape then converts the shoplifting to an armed robbery. And I submit that it does not.
So why is the issue abandonment? I mean, I think if there is money, if there's an open cash register mistakenly left there and somebody grabs $1,000 and walks out and then sees security people coming after him and says, "Oh dear," and drops the money and then pulls a knife in an effort to escape, your view, I gather, is that because the use of the use of the force was only to escape and was not to help steal money, that it's not an armed robbery? Is that?
Yes, and I think that's what the statute says. I think that's what the cases.
But doesn't that, in a way, go against the logic behind our cases and our laws about armed robbery? They have more severe penalties because once you introduce a weapon, it escalates the possibility of violence. And that's exactly what happens here.
There's no doubt when you add a weapon, it escalates the possibility of violence. The question, though, is whether, under the statute, the armed robbery statute, the use of the weapon is to effectuate a taking. In all the cases that are decided, that the Commonwealth cites, that I cite, we describe them at great length, parentheticals in the brief. Each instance where force is used for the first time in the context of an escape, it is in the context of an escape where the person who is doing the taking has possession, is trying to maintain possession, is trying to get away with the property taken. There are no cases that I've been able to find that the Commonwealth cites that suggest that once the intent to take is given up, if some point later in the context of escape or efforts to apprehend that person, a weapon comes out, that somehow converts the abandoned taking to an armed robbery.
But he's trying to escape, and they're trying to hold him there at that
He is not trying to escape with the property. He is no longer trying to get away with the property. At this point, and
well, there is actually evidence that he still had property on him when he escaped.
Well, let's talk about that evidence. There is some, and I intentionally attached that evidence. It's photographic evidence. I attached it to my reply brief precisely so the court would have it handy to look at. And that is.
But going back to the instruction, I mean, we're here struggling with the term abandonment because we don't generally think that's how people usually regard getting caught and dropping the money and fleeing. The judge chose not to use it, but the judge did say that the Commonwealth proves beyond a reasonable doubt that the defendant armed himself with a dangerous weapon after the taking of the property and used that dangerous weapon to effectuate the taking of the property or to effectuate his escape from the scene that would be sufficient to convert the taking of the property into an armed robbery. Why is that? That's basically what you said in explanation to us to clarify this abandonment issue. Why is it clear? Why is it not clearer for the jury to use that language than to use the language which you sought?
Because escape from the scene has never been extended to escape from the scene after having abandoned the intent to take the property. It's a very, very important distinction. If somebody, in all the cases that are on point, are in the context of somebody who is trying to escape the scene and maintain possession of the property. And in this situation.
But I'm saying that the purpose of the laws against armed robbery is the same, even if the person has abandoned the property. The risk he takes of encountering violence, even if he's running out and he's dropping the stuff as he goes, that's all part and parcel of the risk of the armed robbery. That when you go in and take some goods, and with force, I mean, he took these goods, they weren't just given to him.
He took them. It was shoplifting. No one contests that. It was shoplifting. But he didn't use a weapon to take them. He didn't use a weapon to maintain possession of them. He had abandoned them, my theory, on the sidewalk well before anybody, well before is a little overstatement, before anyone put hands on him. So goes.
They were in pursuit, though.
He knew they were in pursuit. They're in pursuit. He drops the stuff on the sidewalk. I mean, realistically, what happens here, okay? And you have stories that go all over the place. But if I were going to step back and say, what as a common sense happened? This guy is being stopped. He opens his jacket. He says, I'm not doing this anymore. Let me go. Leave me alone. They grab him. This is beyond the evidence, okay? They grab him, throw him up against the wall. You're coming with us. They start roughing him up. They're punching him. They're kicking him. He's not intending to complete the taking. He's given that up. And the evidence could have supported...
May I ask you, how much time passed between what you call the dropping and the stopping and the interaction?
Sure.
Seconds?
Yes, it was seconds. I can't tell you the exact amount. It might have been a minute.
All the toothpaste is right there at the scene of the murder.
I beg your pardon?
All the toothpaste is literally, isn't it literally right there?
Yes, let me tell you a little bit about the conflicting testimony on this, okay? One witness says that my client comes out of the CVS, he's chased by 3 or 4 people, goes all the way down past the next block, and then is apprehended all the way down there and brought back. Unclear whether the toothpaste from that person's testimony, that's Hall, is dropped, then he goes all the way down, and then he's brought back to the location where he's thrown up against the wall. That's unclear. If you take the testimony of Young or Laura, who are the 2 CVS employees, it happens within seconds. If you take the testimony of the woman, LaToya Brown, who's in a car at the corner of Brookline and Longwood, she describes it at seconds, but she says she's stopped at a light. She sees the altercation happening on the ground where he's being punched and kicked.
So that would be something for the jury to sort out in terms of the facts.
It absolutely is, and I think the issue of abandonment is something for the jury.
I just press you on this. So under your theory, could a person abandon something seconds before they're about to be arrested?
I think that's a question for the jury. The question is whether someone has truly abandoned it, whether they have truly given up the intent to take.
Imagine a scenario where, okay, a person knows I'm being pursued, as here, and but I'm still going to escape, and I've got my weapon to protect myself. But just seconds before they're about to put their hands on me, okay, I say, all right, I've abandoned it. So now you can't charge me with armed robbery, only with, but I've got my knife, I've got my weapon.
I think that's a situation. It's a harder case than this case, because here we have a series of intervening acts between the abandonment, physical force used against my client, that intervened before any weapon is brought out. But I still think on your facts, Justice Ireland, that it would be for the jury to decide whether that few seconds was sufficient time for the abandonment to convert, so that the shoplifting, let's say, was ended, and the person no longer had the intent to take and was now just trying to escape the scene.
Or is it all part of like one kind of just a flow of, from beginning to end, all part of one scenario?
If there's the notion of flow, I think the notion of flow is also a jury question. I can imagine the prosecutor at a trial where the jury is properly instructed on this notion, distinguishing escape with or escape without possession, that the prosecutor would argue that this was one continuous flow. It was intentional by the defendant to drop the merchandise so it would look like he was abandoning.
Do you have any sense of how much time passed from the time he left the store until he was actually confronted by the store employees?
We don't have that. I think, again, the record fairly read would be a matter of seconds. What happened is there was another patron in the store.
Matter of seconds?
Well,
less than a minute?
It's not in the record. I'm construing the evidence. But let me tell you what the evidence was. There was a patron in the store.
Saw
She
him-
sees him stuffing things into his jacket.
And she
She
tells
goes
one of
up
the-
to an employee. The employee yells for some help, and then he follows. So I think that that's relatively short, but there's no time frame in the evidence.
And while they're yelling, the defendant hears them yelling and exits the store.
I don't know if there's evidence that he hears them yelling or that they yelled within his earshot. The evidence is that he leaves the store and he goes down and he's running around a vehicle parked. All kinds of conflicting evidence about what the vehicle was, but that he's running around a vehicle and he's followed shortly after. There are some bystanders outside shortly after.
Well, in the vehicle, he hadn't abandoned the stuff yet.
Yes, that's correct. He abandons, the evidence is that he abandons the property, the toothpaste, on the sidewalk, close in time, very soon before.
about the-
And in
at the
fact,
point
there's
where-
evidence that says he drops the merchandise as he's being thrown against the wall. So there's conflicting evidence there. Mr. Young, Henry Young, testifies, one of the CVS employees testifies that it was before he was thrown up against the wall. Another says it was as he was being thrown up against the wall. The photo suggests it was before because all the toothpaste is multiple feet away from the wall. You can see that in one of the appendices. There's no doubt that the failure to give the instruction that we requested that differentiated between escape with or escape without, escape with the intent to take or escape without the intent to take, was prejudicial. And
But
I've
where
gone.
is escape? Is escape, does escape, if he's at, does escape end at the store? He attempted to escape from the store with the goods on him.
He did. I'm not sure I understand Your Honor's question. He attempted to escape from the store. He does leave the store. He leaves the store with the property.
Whether the escape is to keep the property or after the property has been...
Correct. I mean, the issue is what's his intent when a weapon comes out, okay? And what happens when by the time a weapon comes out, he has dropped the merchandise on the sidewalk. Some time has passed. He has been thrown up against the wall. He's been manhandled, punched, kicked, the evidence could show. And he's down on the ground, and it's in that context that a weapon comes out.
Could I ask you about the self-defense question?
Sure.
Is it, I'm sure this is clear and I just didn't get it, but is it your point that what you say that the problematic instruction about people who work in a store have the right to use reasonable force to temporarily detain, et cetera, affects the self-defense because it seemed as though maybe I made this up, but anyway, it seems as though the CVS actors were privileged in some way to do what they were doing?
That's absolutely right. It affects self-defense on the element of whether my client's perception that he was reasonably in danger of imminent harm was reasonable. You know, the objective reasonableness of the perception that he was in imminent danger. If the CVS, remember, the evidence in this case was that essentially he was a professional shoplifter. He and his buddies did this to support themselves.
If a police officer had used force to chase somebody who's resisting arrest or something like that, and the same sort of thing, there wouldn't be a self-defense available to your client in that instance?
Well, I think that that's correct. I guess it
And
depends
you're
a
just
little
saying-
bit on the context. You know, if there are 4 police officers standing around my client punching and kicking him,
Yeah, self-defense
even
is
my
available.
client, I'm sorry?
Self-defense is available.
Self-defense would be available.
As an
But
instruction.
if the instruction that's given essentially is an ends justifies the means kind of an instruction, that the CVS employees could use any force so long it was not more than necessary to accomplish the end, that is, to the temporary detention or calling of the police. And so if that in fact were the law, and it's not, and the Commonwealth doesn't even claim that it is, And presumably my client, as a professional shoplifter, would know that. And he would know that the CVS employees were entirely within their right to run out of the store, grab him, throw him up against the wall if he remotely resisted so that they could detain him. I see my time is up.
Yeah, I'm sorry, if I could, why does it matter about self-defense as he was found guilty of felony murder?
Self-defense is relevant to the reason for the weapon coming out in the first place, okay? Whether this was an armed robbery or he was acting in self-defense, it was relevant.
If it is an armed robbery and somebody dies, what difference does it make whether it was self-defense or not? He's responsible for the death.
I think that that's a fair point, okay? I think that if he is convicted, if he can be properly convicted of armed robbery, and we obviously claim that he can't, okay, then he is responsible for the death, and self-defense is not available to him, I believe.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Elizabeth Kosterlitz Martino on behalf of the Commonwealth, and with me is Assistant District Attorney Patrick Hagan, who was the trial prosecutor in this case. I'd like, if I may, to start with the first issue as well, which is the armed robbery instruction. The law is clear in the Commonwealth that if a person's committing a larceny and they're interrupted and they use force against the person who interrupts them, that converts the larceny into an armed robbery. And that's the factual scenario that occurred here.
What if, and I'll go back to my example, there's a pure larceny. There's money in the cash register. No one is there. Guy grabs $1,000, sees people chasing him, and says, drops the money, realizes, and he's running and he's caught, and then after the money's long gone and he has not a penny of it left, he pulls out a knife in an effort to escape. Now he's escaping from the charge of larceny. Are you saying that's an armed robbery because he was using force to escape from what was a larceny, and that transforms that larceny into an armed robbery?
Absolutely. And that's what the case law says. It says if a person is interrupted while they're committing a larceny and they use force against the person who interrupts them, it converts it to an armed robbery. And that's what the appeals court said in Commonwealth versus Rajat, and which is cited in both of our briefs. That's what this court approved of in Commonwealth versus Mavrodakis. It's that if you're interrupted in your larceny, you use force, you introduce force afterwards, after you're interrupted, it converts it to an armed robbery.
Okay, and that's the case even if there is no longer any intent to keep the money because you realize the money's gone.
Right, because at that point you've been interrupted. It's not that you have on your own abandoned your intent to steal. It's that somebody has tried to thwart the larceny and you have chosen to escalate it into an armed robbery. Justice Cowan had said earlier, if you look at the armed robbery statute, the sort of rationale behind it is the potential for injury. We impose greater sanctions for people who commit robberies while armed, not because they're armed, but because of the greater potential for injury, even if they never brandish a weapon.
But isn't it a jury question to determine whether or not the weapon was brandished and used in connection with the robbery, or simply to escape, having essentially abandoned the larceny?
No.
Isn't that a jury question to decide whether the weapon was used in connection with that? And if it is, you're saying it's not?
Well, I have two answers. First, no, because the law is very clear that if you're interrupted and then you use the force against the person interrupting you who's trying to thwart the robbery, that it's still an armed robbery. So my brother suggests...
Well, wait a second. Well, I mean, let's use this scenario. So we have the same scenario. The defendant comes out of the store, sees that there are police around, takes the loot, puts it down, walks away, and he's then chased and takes out a weapon. Okay, is this armed robbery or is this something else?
I won't concede that it's not, but I will say that that's a different scenario because he's not interrupted. He decides before the interruption to get rid of the property. It's very different from the case where the defendant is interrupted with the property and then perhaps decides to get rid of it. And that, I don't think it leaves any question that... It's not a jury question if there's an abandonment. As a matter of law, it's not. And the cases have said if you're interrupted, you use the force against the person interrupting you, it's an armed robbery.
So you say there was no abandonment here?
Exactly. And I don't think that such an instruction is ever required. If it were ever required, which the Commonwealth does not concede in any way, it wouldn't have been required in this situation because there's just no facts supporting it. Again, the defendant had armed himself with a knife before he went into the CVS. He had told Tashia Sneed the day before, if somebody comes after you, I'll F them up. And so today, the day of the murder, he has the knife on him, he's interrupted, and he uses that knife to F the people up.
Now what do we do? And I've not had a chance to look at the cases, but in the blue brief, page 30, Commonwealth versus Marcotte is cited and said that robbery through assault requires objectively menacing conduct by the defendant undertaken with the intent to put the victim in fear for the purpose of stealing his property. And Mr. Krupp says, well, his purpose at that time was not to steal the property. He had already given up any hope that he was going to keep that property. His purpose then was simply to escape from being caught and having his probation revoked and going back to jail.
Again, I think it just goes to the question of, can you abandon something when you're interrupted? And I think that the answer is no. And I think that the cases have said as a matter of law that the answer is no.
So even if the intent is no longer the purpose of stealing the property, but simply the purpose of getting away from a larceny that you already committed, you say that's still armed robbery?
Yes, because you're and I would actually point the court to McGuire and Commonwealth versus McGuire, Commonwealth versus Griffith, Commonwealth versus Vives, which I cite in my case, in my brief. Those are the cases that say you're not entitled to self-defense during an armed robbery. And they say even if the victim uses...
Yes, but isn't the question whether this is during an armed robbery?
Absolutely. And
so we can't use those cases.
Well, no, but in those cases, they say if the victim intercedes to apprehend the robber or to prevent the crime, then, it's still an armed robbery. So if it's to prevent the crime in the first place, it would seem, the logical extension of that is that the person may... what was my purpose? If it's to prevent or to apprehend the robber, at that point, the person may, it's an interruption. The person may have dropped the things, may have said, this is no longer a good idea, but they didn't do it before they were ever interrupted. And so the force is used to finish the crime. And all of the cases say it's a continuum, to look at it as a continuum. And there's not one case that I could find that says if a person's interrupted, all of a sudden they get this instruction that says, let's see if they really intended to steal.
So you used the word continuum, I used the word flow earlier, but your view was this was all part of a continuum from the time the person left. We don't know whether he heard the store employees making words to the effect of, let's get this guy. We don't know whether he heard anything.
Right.
How much time does the record suggest passed between the time he left and the time they confronted him?
I'm not sure. It was the victim, Christian Giambroni. He ran after the defendant right away, and it was around the corner from the CVS. So I would say a matter of seconds, most likely. But I would also note that the instruction as given. So first, the Commonwealth's position is that this instruction is never required. And secondly, if it is ever required, it's not required on these facts. But the third contention is that even if it is required, and even if the court finds that it's required on these facts, the instruction is given, I think, is adequate to convey to the jury that, listen, the judge said if you find that he used the force for a purpose unrelated to the taking or the completion of the taking, then it's not armed robbery. So I would say that part of the instruction.
That's how you interpret, that's what you think the gist of what she said is?
Well, she did. She did
or
say
did
it.
She say that exactly?
Yes. It's in the Commonwealth's brief, page 26. She says, and this is a quote, if, however, the defendant armed himself with a dangerous weapon after the taking of the property for a purpose unrelated to the taking or successful completion of the taking of the property, that would not be sufficient for armed robbery. So I think even if this type of instruction is ever required, and even if it was required on these facts, it was adequately conveyed to the jury, and so it could still have been a jury question, and the jury obviously resolved that not in favor of the defendant. And as to the second issue with the so-called shopkeeper privilege, I think it's really a red herring. It doesn't matter. The jury was properly instructed on self-defense. It's irrelevant what the shopkeepers were allowed to do. So I don't think that it matters at all in this case. And
do you agree that it was that it was not a proper instruction?
Most likely, I don't see why it was given, but
I mean, it really
doesn't matter.
has to do with protecting against some claim of false imprisonment or something.
Yes,
doesn't
it's a
it?
defense to false imprisonment, or it's if the CVS employees were the defendants and they were, being charged with assault and battery or something, it's a defense from that perspective as well. I think what's more important also is in this case, the defendant wasn't entitled to self-defense for the very reason that he was committing an armed robbery, and the cases are clear. Those are the McGuire, Griffith, Vive, that if somebody's committing an armed robbery, they do not have the defense of self-defense.
Well, of course, his defense was that he had abandoned that, and he was then under assault by 4 people whom either some or all of them were armed, and that he was essentially fighting for his life, and that's why he pulled out his knife.
Right.
So why under that view of the facts, is the self-defense instruction warranted?
Well, because I think the premise is erroneous as a matter of law, that he could have abandoned it, and that it's ever even possible when you're interrupted
So
to...
you can't abandon, once you've taken property out of a cash register or from a shelf, you simply cannot abandon that as long as you have the property.
Well, no, I think you can, but not by virtue of an interruption. Not because somebody is chasing you and grabbing you to thwart the robbery or the larceny. I don't think that you can abandon it under those circumstances. So
As a matter of law.
As a matter of law, I think that the premise is erroneous. However, even if, and so he was committing an armed robbery when he introduced that knife, and therefore he does not have the right to self-defense. Even if the court disagrees and accepts my brother's argument that it can be broken up into these small parts, I would argue that there was no reasonable belief that the defendant was in serious, belief that he was in imminent fear or imminent danger or of serious bodily injury. The defendant himself said that when the CVS employees attacked him, that he reacted. They grabbed him and he reacted. He said himself that he reacted because he didn't want to go to jail. I think it brings us into a Commonwealth versus Pike situation. This defendant's own statements were that he reacted because he didn't want to go to jail, not because he felt that he was in danger of serious bodily injury or death. So I think...
You don't, just objectively, if you've got 3 people on one and pounding and hitting, that there isn't going to be some issue about self-defense?
I don't think in this case, because of the defendant's own statements, that he reacted and that he stabbed the boy, which he also said, it was because he didn't want to go to jail. I think under those facts, it's just he wasn't entitled to a self-defense instruction. And I did want to...
Could I ask
Yes.
you, please, about the closing of the courtroom?
Yes.
Does the record show how large the back door is?
No.
It doesn't. And is there any evidence about whether the courtroom was open as seats became available because jurors were excused or seated on the jury?
Completely silent. The only evidence in this case as to the courtroom closure is that the defense put on the record, my client's mother is here, she wants to watch jury empanelment. The judge said, we'll leave the back door open, she can watch, but she shouldn't mingle with the jurors, and that counsel said thank you.
Okay, is this another case that we might need to remand for a hearing?
I would argue no, for the first reason that the courtroom wasn't closed because the back door was left open. And for this,
But might it have been closed because the judge said nobody could, well, the room was full of jurors, and we don't know if once jurors were excused or seated, whether other people were permitted in.
well, I would argue no. I would argue that, that the door was open meant that the courtroom was open. But secondly, if the court disagrees, I think that the defendant waived it in this instance because he said to the judge, this is the problem. The judge offered a remedy, and the defendant accepted that remedy.
Yeah, it's not that so much that he said thank you. It's simply that he seemed to be satisfied with that remedy and didn't say, no, Your Honor, that's not good enough.
Right.
We're
Please
gonna have
preserve my, sorry, yeah.
so that he really did raise an issue. It was satisfied, and they moved on.
Yes. And I would like to just say one more thing about the courtroom closure. Even if, and of course the Commonwealth is not saying this, but even if it was a partial closure, and even if it wasn't waived, I do think that the 4 Waller factors were met here for a partial closure. In Cohen, the court said that the proponent must advance a substantial reason for the closure, and that, the juror jurors taking up all the seats is a substantial reason. So I think we have
Well,
that.
it certainly is at the beginning, but my question goes to when they were removed, when some were removed.
Right, and it is the defendant's burden, I think, to show that the courtroom was closed. There's nothing on the record, and this was at the very beginning of jury impanelment that this was put on the record about the mother. There's absolutely no showing by the defendant that there was any prevention of letting people to come in as seats opened up. And that is what Cohen said was the problem. And Cohen, this court said, that judge or court officers need not undertake an affirmative effort to seek out spectators. The only requirement is that they may not prevent spectators from coming in. Defendant has not shown any way that that happened. The reasonable alternatives to closing, I think, were here, that the door was left open, that people could look in, and finally the findings on the record in the partial closure, it just has to be evident from the record itself, and I think here it's more than evident. So even if there was any type of partial closure, and even if it wasn't waived, neither of which the Commonwealth concedes, I think even still, they were justified, and the record bears that out.
In reading the briefs on this separate issue, the issue of whether the replacement medical examiner could properly testify the way he did, there's really, I haven't read the transcript, but in the briefs it's hard to know what, in fact, he's testifying to. Did the substitute medical examiner essentially say, here is what the medical examiner who performed the autopsy found, A, B, C, D, E, F, G, or was it something different than that? Did he say, I've looked at all this material and here's my opinion as to the wounds and the cause of death, et cetera? What was it?
I believe it was the latter. I'm not positive on that. I think it was more that I've reviewed everything. I know he did say that he had reviewed everything and that the cause of death was a stab wound to the neck. He did testify about the trajectory of the wound, but I don't think it sounded like this is what someone else found and I'm parroting.
As opposed to, I've looked at all this information, I'm an expert and this is my opinion.
Yes, and certainly as to the opinion of the cause of death, that was how he testified. Some of the findings did come in, and I don't contest that, but I just don't, I think they were harmless beyond a reasonable doubt, especially in this case because extreme atrocity was not an issue. It was a felony murder. That was the only theory on which the jury convicted the defendant, and the cause of death was just not in dispute. In fact, the death certificate came in saying that a stab wound to the neck was the cause of death, and the defendant didn't contest that coming in as part of the death certificate. So it really wasn't an issue.
Oh, I'm sorry. There were 2 counts of armed robbery charged
Yes.
and found guilty of both?
Yes.
And what were the 2 counts?
The defendant,
Why 2?
So Henry Young, who was the manager, he was stabbed first by the defendant, and he fell down. He was stabbed in the abdomen but lived. And then Christian Jambroni was stabbed in the neck and died.
And that means it's 2 counts of armed robbery? He wasn't stealing from them.
He was stealing from the CVS, and they were the property. The people
Did you
who had
have
the
2
property
counts of
interest.
armed robbery because there are 2 counts of felony murder? No, obviously not 2 counts of felony murder because he didn't die. But it's 1 robbery, isn't it?
No, I think that the law is
because
that
it's 2 victims?
Yeah, the 2 victims, and the property has to be taken from somebody who has a property interest in it, and I think it's that both the manager and Christian Jambroni, both of whom worked at the CVS, had a property interest in the property of CVS, in the toothpaste boxes. And if the court has no other questions, then the Commonwealth will rest in its brief.
I misspoke in response to Justice Gantz's last question to me. If I could submit a letter to correct that.
You may.
Thank you.
Thank you.
Thank you, Your Honors.
So we're going to take a recess.